Okay, let's continue on with our English law series, and we were just going to start to dive deeper into the Cestui Vi Act of 1707. Now, even though we are jumping from 1540 to 1707, I don't want to infer that there aren't any other acts in between that we should investigate, such as the 1688 Bill of Rights and the 1707-1701 Act of Settlements, to which I will guarantee that I will address in later videos. Now, these before mentioned acts will create some depth so that to assist us in arriving at the answer as to whether the law has been perfected in each individual's favor, as I have so far claimed in before videos. Now, I was listening to a well-known British historian by the name of David Starkey, who is well known for his colorful depiction of British monarchical history, especially the study into the Tudor dynasty. Now, one of his videos that I listened to, he was part of a chosen roundtable group in front of a live audience who were discussing the merits of the Magna Charta as a constitution, and to which I'll attach the link so that you can take a look at it as well. It's very interesting, the discussion about how the Magna Charta is or isn't a constitutional document. And David essentially said it is just merely all guff and does not serve as England's founding constitutional document, to which I will have to agree with them, but not for the surface level views he offers to the instituted masses, as he never discusses the core issue, that core to which we are now studying in this English law series, and that is the law of the land, which is studied would remove most of any historian's spin on history and on the monarchy's reasons for making any of their regime changes, such as the underlying driver for the Reformation during King Henry VIII's reign, whereby the accepted reason for Reformation of that time, during the reign of King Henry VIII, claimed by such an astute historian as David Starkey, and as well as backed by Encyclopedia Britannica, is for romance mainly. Henry, essentially, wanting an annulment from Catherine of Aragon, so as to hold the hand of Anne Boleyn, who later became, during that era, the mother of Elizabeth I. Now, I digressed a little bit, but back to the Magna Charta. At that time, when it was first drafted, it lasted only about 6 weeks. At that time, we have 4 different land tenures, which were developed initially under the reign of William the Conqueror, or William the Purchaser. In this epoch, the king was supreme owner over all land. The barons and lords who held the tenure in the king's prerogative were divided in fee between the Norman military tenure, which provided the armed force, the armed enforcement for the kingdom. There was the agricultural proponent termed the socage tenure, and the Saxon component for those who bent their knee so as not to lose their status held before the Norman conquest, was the serjeantry tenure. And lastly, not in fee, was the Franklemon or Franklemon tenure, the church namely, which was established to take care of the giver's soul. 3 of those tenures were controlled within the common law. The church was a different creature altogether because it was a perpetuity personality, so of notice that it is absent of life. Therefore, the king had no right to receive the incidents, marriages, and wardships that he received from the other tenures because it was held in right of the church, who had a different interest altogether. That namely, a use to land that later became known as an equitable use. And I'll agree with David Starkey when he refers to the Magna Charta as not being a foundational constitutional document for the people, since no king was held to it, especially when we arrive just over 200 years later in the reign of King Henry VII. To which one can simply ask, then, where was the force of that document then? The other reason not shared by this Cambridge former student of history is that the document itself has nothing to do with the equitable use to land, nor does this ancient document concern itself with the majority of the people. The majority are not included because they are not seen in the common law courts, since they hold no title in the immediate right of the king. It was a contract between the king, the barons, which is the tenants and capite, and the mean lords, those comprised of Saxons mainly, and those consisting of lower level status tenants, which namely are the mean lords. Those are the parties of interest relating to this document, the Magna Charta. All the elite of that time mainly, so as to secure rights for themselves and their bloodline, were party to the Magna Charta, so nothing to do with those who held copyholds, for instance, those who held no common title or common law titles, but rather a right only consisting of protection while they labored upon the same land of those lords. A copyhold, to give some meaning to that, was merely a description of accounting that ended to be settled, or that needed to be settled, that outlined the duties to be fulfilled by the persons who held a right to maintain these lesser estates carved out from a common law legal title. Is it any different than today in theory, whereby the majority of the people do not entertain a seat at the elite's table? The elite have grandfathered agreements of common law inheritance, titles to land that essentially secure their own future bloodlines, not those of a lesser right. The right to control a common law right in land, where the majority are subject to a trust agreement concerning their legal estates and property rights as assumed owners, indirectly under the common law titles held by these same elites. In layman terms, how is today's property rights really any different than those under the feudal land tenure system? Except that today one accepts a legal title to an equitable use to land only under a trust for sale scheme, and so they are assumed owners subject to equity, thereby not seen in the common law. Well, if we look back at that time, were the people seen in the common law either? No. This simply means one does not need direct permission or granted favor or has to swear allegiance to any lord or monarchy before one can have a right to purchase a title, so as to gain the privilege, the legal right, to convey this equitable title at their own will. Today, the purchase of property means it is good against all the world who have the same right. Thereby one is purchasing a right to an action, a lawful remedy which creates value in this security against any subsequent trespass or right of entry, etc. If historians merged, such as David Starkey, with the law, I suspect history would be more easily understood, and this, the fiction, the color, and the emotion taught in today's learning centers would be seen as just that, nothing more than to serve as an interest piece, so as to create personal connection with its subjects, which the law does not entertain. Where's our remedy to the common law? This remedy is found in the Cestui Act of 1707, and the warranty later determined in the law through the Settled Land Acts. On that note, let's begin a new video. If you like this series so far of where your true rights to person and land are, please like, subscribe, and share. And thank you also for all those who have donated this far in sharing in my research, so that we can continue on with our own learnings of how we not only free ourselves, but of course free future generations from the oncoming Orwellian state of affairs. With that, I can see it's just 9 minutes. Why don't we conclude here and excuse me, move on to the Cestui Act of 1707.